Hi guys, welcome to Learn Kenyan Law with Wanjiku. Today's session is under the law of equity, and today we're going to be discussing what is equity. How did the law of equity develop? What is the origin of the law of equity? So let us ask ourselves, what is equity? It is important for us to note that we have the literal meaning of the word equity and there is also the technical meaning of the word equity. So the literal meaning of the word equity generally means fairness. According to the Oxford Dictionary, equity is a system of natural justice allowing a fair judgment in a situation where the existing laws are not satisfactory. So the literal meaning of the word equity generally means good faith. It means, doing right. It means being honest. It means conducting yourself in an ethical way when you're dealing, in transactions and in relationships. So let us go to the technical meaning of the word equity. So in the legal sense, equity is the branch of law which before the Judicature Act of 1873 came into force was applied and administered by the Court of Chancery. So let us now dive into the historical origin and development of the law of equity in England. The most important thing for us to note is that during this time, the common law was the only kind of law which was governing England. And of course, the common law developed over the years and it was administered by judges who were selected by the king. And during this time of common law, there were only three courts. We had the King's Bench, we had the Court of Common Pleas, and we had the Exchequer Court. The King's Bench Court, just like the word is saying, this was generally where the king used to come with his judges and they would sit on a bench and they would listen to the civil and criminal cases which the king had an interest in. We also had the Court of Common Pleas. The Court of Common Pleas generally dealt with civil cases which were brought by one individual against another individual. We also had the Exchequer Court, and this court specifically dealt with cases that were affecting the royal revenue. This is to say those cases that were about taxes. So it is also important for us to note that under the common law system, there was the writ system and the doctrine of precedent. So generally, this is saying that a person could only get redress for their grievance if there was a writ disclosing the course of action. It is also important to note that there was a specific statute called the Provisions of Oxford of 1258, and the Chancellor could not issue any new writs that were not there. So for example, if a person has a grievance and there is no writ which is available for him to disclose the kind of action that should be taken, that person had nowhere else to go. So of course, this made common law system very rigid. And it is also important to note that sometimes even you've gone to the common law courts, you're a plaintiff, the defendant has been ordered to conduct himself in a certain way or to do a certain thing, and the defendant ended up not doing it. Of course, as the plaintiff, you'd feel intimidated. You would feel like there is some injustice. So as this went on, what the plaintiff decided to do, they would go to the king, and they would implore to the king to do something about their cases. And of course, the king was in a position to exercise his extrajudicial powers. So the king used to use his extrajudicial powers, and of course, he would start giving orders, different kind of orders, depending on the specific cases. So of course, a lot of people started coming to the king. And because of all this, it gave rise to the establishment of a court of chancery. And of course, the king had to appoint a chancellor who was now in charge of the specific court of chancery. And of course, when we continue, we're going to see that when it comes to the court of chancery, it was basically on the notion of conscience of the specific chancellor. So this is where the notion of equity is as long as the chancellor's foot phrase was coined. Generally meant that equity was what the chancellor decided was equity. Because as we have said, it was dependent on the notion of the conscience of the specific chancellor. Of course, it was difficult because what would shock the conscience of one chancellor would not necessarily shock the conscience of another chancellor. So, of course, this court of chancery provided a remedy to mitigate the harshness of the common law. And another important thing to note is that if the common law rule was too rigid, what the chancellors used to do, they would leave it alone and instead they would develop a new rule. So scholars have been saying that equity came to fill in the gaps which were left by the common law, or rather equity was also seen as aiding and supplementing the common law. Another important thing for us to note is that equity and common law are very distinct, because equity appeared at a later stage of legal development as compared to common law. Because as I have said, common law was there. By the time people needed equity, common law had already developed. So it is important for us to note that equity was very distinct from common law, and that is why we define it as that which is not the common law. Because as I have said, it developed separately and it came after the common law. So let us continue about the Court of Chancery. Of course, there came a time where equity became systemized because over the years, other chancellors would look at the previous decisions of other chancellors to just find similarities, so that they can follow a specific precedent, just like what used to happen under the common law. So, of course, the rules of equity they started to become fixed. Let us now note that we have 4 courts, We have the King's Bench, we have the Court of Common Pleas, we have the Exchequer, and now we have the Court of Chancery. So another disadvantage started happening. The litigants would now start getting thrown from one court to another because the common law courts could only award damages. However, the Court of Chancery only had power to award injunction and specific performances. So you would probably find a plaintiff that would want an injunction and still would want a damage. So the plaintiff would have to go from one court to another court to another court, which of course there was a lot of rivalry between the common law courts and the Court of Chancery. So what ended up happening, the Common Law Procedure Act of 1854 came up. And the Common Law Procedure Act of 1854 gave the common law courts a limited power of granting injunctions. Of course, this was something that was not there before. As I have said, the common law courts could only give damages. They could not grant injunctions. So after the Common Law Procedure Act of 1854 came up, now common law at least had a limited power to grant injunction. And then 4 years later, the Chancery Amendment Act of 1858 came up, and it was able to give powers to the Court of Chancery to also award damages. So if you see what has happened here between 1854 and 1858, is that the two courts were now able to mitigate the disadvantages of each other courts. These two courts now are able to complement each other. And there's a very important case that is G versus Pritchard, where Lord Diplock was asking that there has to be a balance that should be struck, to avoid inconsistency. So generally what we're meaning here is that when the new body of rules came into existence, it meant that whatever claim one had in equity had to be accommodated by equity. Another important case law that we need to talk about when you're talking about the historical origin of the law of equity is the Reed-Diplock case, where the judge was saying the Court of Chancery is not there to invent a new jurisdiction. So the Court of Chancery had its own work, and of course the common law court had its own work. So of course with time, there had to be a merger of two courts because now we have the common law courts and now we have the Court of Chancery. So the Judicature Act of England of 1873 and 1875 was able to merge the two courts. So now we had 5 divisions. We have the Queen's Bench, we had the Common Pleas, the Court of Common Pleas, we had the Exchequer, and we had the Chancery, and we had the Probate, Divorce, and Admiralty Court, which generally dealt with disputes involving the high seas. We continue, and then in 1880, there was an order in council, of course, which reduced these courts to 3. Remember, we've started with having those 5 courts. Now we're at 3 because now we have the Queen's Bench. Now we also have the Court of Chancery, and we also have the Probate, Divorce, and Admiralty Court. This was during 1880 because of the order in council. And then, of course, as time went on, in 1970, the Administration of Justice Act of 1970 occasioned more changes, which was the Probate, Divorce, and Admiralty Court now became a family division. So meaning that matters that were dealing with Admiralty, they were now taken to the division of the Queen's Bench. So now how many courts do we have? They only ended up having 2 courts. That is the Queen's Bench, and the Court of Chancery. So that is the historical origin of how the law of equity was able to evolve. As we have said, there was only common law in England, and there were only three courts, which was the King's Bench and the Court of Common Pleas and the Exchequer. However, we continued because of the rigidity of common law. There had to be the Court of Chancery after the king used to be implored by the plaintiff. So, of course, we continued again, and there was also a need to now merge the two courts together, which gave rise to the Judicature Act of England of 1873 and 1875, which now made the High Court to have 5 divisions. That is the Queen or King's Bench, the Court of Common Pleas, the Exchequer, the Chancery, and the Probate, Divorce, and Admiralty Court. Then we continued to 1880. There was the Order in Council, of course, which reduced from 5 to 3, where we had the Queen's Bench and the Court of Chancery and the Probate, Divorce, and Admiralty. Then again, we continued to 1970, where we have the Administration of Justice Act, which now reduced them even to 2, because now the Probate, Divorce, and Admiralty became a family division, which was taken to the Queen's Bench. So they ended up having 2 courts. So, of course, an important thing to note is that equity came to mitigate injustice because it was providing remedies that were not available in common law. And we're going to see which kind of remedies were there and which kind of maxims of equity are there under the law of equity. So thank you so much for joining me. I hope this has been a learning session for you. And in case you feel like you want to contact us, feel free to subscribe, of course. Feel free to write a comment down here. Of course, feel free to also reach out to my email. See you guys. Bye.